File 251722 SC here for arraignment on a felony complaint. Sir, at the JJC, can you state your name for the record?
Daniel Canales.
I'm sorry, could you just repeat that? It broke up on me a little bit.
Daniel Canales.
All right, sir, you're here for arraignment on a felony complaint. Mr. Kennedy here for arraignment. How would you like to proceed with that arraignment today?
Thank you, Your Honor. John J. Kennedy, P51549, representing Daniel Shane Canales. For purposes of arraignment only, I've discussed with him his constitutional as well as his statutory rights. In addition, I have reviewed each charge and read them to him along with the maximum penalties. As to the charges themselves, we're going to waive formal reading. My client would stand mute. I'd ask to have a not guilty plea be entered on his behalf. Going to request court-appointed counsel, and I would ask to have this speak to bond.
All right, we're going to waive formal reading, stand mute, enter not guilty, set a probable cause conference, grant court-appointed counsel. From there, I do have Mr. Hall here on behalf of the people. I'm going to allow him to go first. I'll give you an opportunity to respond. If you can't hear him, I know the audio is not optimized for Zoom proceedings, but if you can't hear him, let me know. Otherwise, Mr. Hall, floor is yours.
Thank you. Good afternoon, I'm Jeffrey Hall on behalf of the people. This time he's asking for $1 million bond on this individual. While he has no criminal history and all the severity of his charges, a light offense stemming from really a property crime, which is a very small offense. I've estimated his guidelines starting around 19 years at the bottom end, so he is facing a very high sentence. If convicted, likelihood of conviction, I believe in this case, is extremely high. The entire incident is on camera from start to finish. There's no issue of identification. It's really just an issue of what the eventual conviction would be, what type of homicide. I believe the defendant shows a lack of regard for authority, shown by the fact that he ran 2 different police agencies during this event. His driving in this incident that led to the crash shows a lack of regard for public and human safety, both the public and himself, reaching speeds of up to 30 miles an hour during the chases, as well as I believe there's the fact that the 16-year-old was out at 2:30 in the morning, 12-year-old stealing cars shows a lack of parental authority or supervision of the defendant. So I do believe that the defendant does pose a risk to the public. I do believe that there is a concern for him to show up at court given the severity of the offense, possible sentence, and lack of home supervision for a minor. So I am asking for what I understand. It is a high bond, but I think it is appropriate in this matter.
All right, and I know there was mention of other parties. There's no co-defendant, at least on the
12-year-old is
juvenile
system.
Okay. All right, just making sure. Mr. Kennedy, go ahead and response. You got to unmute, John. Yep.
What was the number?
He's asking for a $1 million bond.
On behalf of my client, I would ask for a lesser bond, Your Honor. On behalf of him, I'd like to be able to, him being at a certain age, the possibility of being at home, the possibility of, if not cash surety and cash surety with 10% with a tether. I would like to be able to give him that opportunity to be easier to be able to meet with his future attorney on this matter. In addition, if the court does state a higher bond, I would ask that my client be evaluated by community corrections for psychological issues, as well as bond reconsideration. And separate of bond, they're based upon what I read in the information, the complaint for the felony, there might be a jurisdiction issue in which I'm not quite sure if the if some of the charges took place in Clinton Township, that might be in a different jurisdiction. I needed to bring that up on the record.
All right. All right, when setting bond, I have to look at factors related to risk of non-appearance as well as risk of danger to the public if released. Any factors related to those 2 prongs as outlined, frankly, by both parties. Obviously, given the defendant's age, there's a lack of criminal record, fortunately enough, which at least up until now demonstrates that he's made all of his court dates because there haven't been any. That being said, in as much as I can consider the nature of the offense for something that someone is innocent unless later proven guilty on, I have to take that into consideration. The circumstances involved here, as outlined by the prosecutor, definitely give way to a serious concern for risk of danger to the public, a serious concern for risk of flight, just in the nature of the charges as they're written. Anything jurisdictional would be an issue for the next court date. I'm not going to get down the rabbit hole on that today. Those are all motions that can be made once council's appointed if they feel that that's necessary. Quite honestly, MCR 6.106 takes into consideration the fact that our fundamental right is the right of liberty. And that's not something that should be taken lightly, something that only in limited circumstances would we be able to deny somebody bond altogether. And quite honestly, this is one of the cases where that could be considered. The people are requesting $1 million bond. Frankly, I don't think that's unreasonable, but I have to figure out the least restrictive means to ensure that the defendant appears to court and is not a risk of danger to the public. And again, not getting too deep into the facts of the case because I'm not a sentencing judge and we're not here to try the case today. But some of the facts that have been put forth today are of extreme concern to the court when I'm looking at things such as risk of danger to the public and risk of flight, and that I think the facts provided demonstrate both of those to the utmost degree. So I will refer it for a bond assessment. I'll refer it to CMH for an assessment as well. I think I also need to address whether or not, as a juvenile, he should remain at JJC pending trial. Any objection from the people in that regard?
No, we request to stay at JJC.
I would request that also, Your Honor, on behalf of my client.
And the people agree. So I'm going to allow him to remain at JJC pending trial. I don't think there's any issue with that. I think that's probably the best case scenario for everybody involved here. But at this point, pursuant to MCR 6.106B, I'm going to remand the defendant without bond. And that can be readdressed at the next court date. That court date will be July 28th at 8:30 a.m. on Zoom with Judge Femininio. And Mr. Canales, I would just indicate to you that the court will process your request for counsel. That's done through an independent agency. An attorney should be in touch with you within 72 hours of notice of their appointment. I don't have any way to guarantee how fast they are going to get notice of appointment, but I would just caution you not to say anything about your case to anybody except for that attorney, just in the interest of making sure you don't say something that could potentially be used against you. So make sure you're not saying anything to anybody about your case until you have talked to your attorney and have that attorney with you. Does anyone have any other questions at this point? 8:30 a.m.
No, Your Honor, no questions, and I did discuss that with my client.
Okay, go ahead.
Will the court be setting when their exam date as well?
By default, it would be the next week to stay within the statutory period. We usually don't formally set them right away, but if the
That's fine.